A lot of people who got into cryptocurrency because they saw it as the Wild West and it was beyond regulation, and that's what they actually liked about it.
The government will consult with industry and hopes to have new laws in place by early next year.
In today's video, I'm breaking down blockchain tax case from a different perspective. This ruling could completely transform how courts handle cryptocurrency. We will look at this case and explain why I think the outcome was a little underwhelming. But most importantly, we will discuss on what extra steps the court might take in the future and what are the challenges faced by the creditors. In particular, how recovery and injunctive actions can be taken against the owners of cryptocurrency. Here's the story in a nutshell for the case. A blockchain company sued its former secretary and her husband to recover 36 bitcoins that were supposed to belong to the business. The secretary also received another 25 bitcoins on trust to be sold for the company's working capital. But instead of returning the proceeds, she kept them for her personal benefit. At the trial, the court had to answer, are these bitcoin properties that the company can claim back? The judgment was massive. 220 pages and 17 parties were involved. But the headline is simple. The court ruled Bitcoin is property. It's identifiable, it can be controlled, it can be traded globally, and it has some forms of permanence. That's a landmark decision before which there are some judicial views that cryptocurrency is mere interesting information. In my previous video, I analyzed how did court give weight on unique features of public key and private key of Bitcoins, whereby ruling in favor of the blockchain company's recovery of 25 Bitcoins from its former secretary. The court basically said that those Bitcoins were held in trust and any sale proceeds should be returned to the company. The court in particular relied on the 4 criteria set out in Lord Wilberforce's classic definition of property in National Provincial Bank and Ainsworth. Now, why did I say it was underwhelming? 2 reasons. Number 1, the damages were calculated at the price of Bitcoin back then, not today. Instead of millions, the company got far less. Secondly, the lawyers of the Bitcoin company didn't frame their pleadings to go after all the stolen Bitcoins. That means we missed a chance to see how the court would treat third parties who benefit from misappropriated crypto assets. Let's look at the first issue, damages calculation. Before we start, let's figure out what are the common types of remedies. When it refers to compensation in the court of equity, common types of equitable remedies include restitution for unjust enrichment, account for profits, constructive trust, etc. Let's take restitution for unjust enrichment as an example. Imagine you accidentally transfer $1,000 to a wrong bank account. The person who got the money shouldn't be allowed to just keep it. That's unjust enrichment. Restitution makes somebody give back a benefit they shouldn't keep. Another example is account for profits. Say someone copies your invention and sells it. You may not have lost the sales yourself, but they made $50,000 in profit. The court can order them to hand over that $50,000 to you, and account for profits allow you to take the profits that are supposed to be yours. Then how about constructive trust? It's like the court stepping to say, this property isn't really yours, you are just holding it for somebody else. So the court officially recognized that one person is holding property on behalf of another. In blockchain tax case, the orders regarding constructive trust as a remedy were made. The secretary was said to have breached her duties, not by selling 25 bitcoins, being assets of the trust, but in not remitting the proceeds from the sale. However, the court assessed the damages at the date that the secretary sold 25 bitcoins but failed to transfer the proceeds back to the company. The damages were not assessed at the date of the claim or the date of judgment when the Bitcoin prices were rocket high. Fair or not fair? What do you think? Bear in mind that damages can be different depending on course of action. As you might recall, the secretary was transferred 2 tranches of Bitcoin. One was 25 Bitcoins, the other was 36 Bitcoins. Although the court held that 25 Bitcoins were held by the secretary in trust, but the court rejected the Bitcoin tax claim in respect of that 36 Bitcoins. Why, and what's the difference? Because different from 25 bitcoins that were kept and sold by the secretary herself, the 36 bitcoins were transferred to others' digital wallets that were not known to the court. The court considered that the constructive trust was not properly pleaded against those recipients. The court said the plaintiffs have not sought leave to amend the pleadings to include those recipients to the proceedings and to make claims against them. Also, the blockchain company mainly relied upon its argument that those 36 bitcoins were the company's assets subject to Bailment, and the company was entitled to immediate possession at call. The term Bailment was well defined back in 1971 in Hobbs and Petersham transport case. In simple terms, it refers to delivery of goods without transferring ownership, and whoever received the goods is obliged to take care of it. Your weekly laundry is a good example. You hand over your suit, the dry cleaner keeps it to clean, you still own the suit. Their job is to look after it and then return it to you in good condition. The problem is certain forms of intangible materials such as bitcoins are incapable of being touched or felt, and they may not be physically possessed. If they cannot be physically possessed, then there is no right of Bailment. The court therefore completely rejected the proposition that Bitcoin is capable of being subject to a legal relationship as a Bailment. But I do think the lawyer representing the blockchain company did this in a strategic way because there is an advantage for Bailment argument. I mentioned earlier that damages can be different depending on the course of action. If the Bailment argument becomes successful, the natural consequence is that the secretary needs to return the entire 36 bitcoins rather than the equitable value at the price of bitcoins back then. When the Bitcoin price was 10 times higher in 2024 compared to its value in 2018, I would say the lawyer acting for the blockchain company was trying to fight for the most ideal outcome for their client. But would things be different if constructive trust is better pleaded against those third-party recipients? We wouldn't know. We lost the rare opportunity to observe what the court might do against the third party who receive benefits from misappropriation of crypto assets. I believe that one day in the near future, there would be certain orders regarding injunction or recovery of crypto assets. But then it brings the million-dollar question: how to enforce recovery or injunction orders concerning bitcoins or other cryptocurrency. Enforcement action involving cryptocurrency isn't as straightforward as enforcing one about a car or a house. Things will be different depending on whether the crypto is sitting in private digital wallet or in an exchange platform. Let's talk about digital wallet. Some of you may heard about the story of Silk Road. FBI took years to trace the founder of this dark web and could not find him until he left his laptop open in a library. If the defendant has hidden the Bitcoin in a hardware wallet, cold storage, or unknown address, it's technically impossible to force a transfer unless the defendant discloses the private keys. Yes, you may obtain some orders compelling him to hand over the wallet, such as examination order, to disclose the keys or whereabouts of the USB sticks. In urgent cases, you may ask for an order permitting court-appointed officers to enter premises and seize hardware wallets, USB sticks, phones, laptops, etc. But courts require very high threshold for ex parte search orders like these. And it largely depends on the person's willingness of cooperation. Yes, you can even initiate contempt proceedings and criminalize him if the person keeps resisting. But it is costly and he may not even care. The court may then order payment of equivalent value in dollar amount instead, which can be enforced against other assets, such as his real estate property, wages, and bank accounts. But realistically, most debtors would have sold those assets already and converted them into crypto. Let's look at the scenario where cryptocurrency is saved in exchange platform. If the crypto is on exchange, then there is a chance that you may seek freezing orders and interlocutory application for that exchange platform to disclose those account details. Court can order exchange platforms operating in Australia like Binance and Coinbase to freeze accounts and preserve funds pending determination. But before doing so, you may need to think carefully and consider the following issues. Firstly, whether you have a good arguable case on the substantive claims such as fraud and dishonesty, which may warrant an ex parte injunction order to be granted on the same day or the next day of your application. The stronger your evidence and tracing report, the more likely urgent relief may be granted. Second, speed is the key. Once the other party knows what you are doing, the assets might be transferred or dissipated. So you need to do it in a fast but secret manner. You need to prepare a large volume of evidence within a very short period of time. Make sure you get the lawyer that is capable and can work 24/7 for such kind of case. Thirdly, think about the risk-reward ratio. You may spend considerable time and resources, but find out there is only 0.05 Bitcoins in the account, which is inadequate to cover your legal costs. You need to be more realistic. Sometimes the only practical recovery is a monetary judgment and enforcement against the more conventional assets. Number 4, undertakings to damages. If you would like to free somebody's assets, the common condition is that you have to provide an undertaking to compensate the defendant if the orders were wrongly made. Number 5, cross-border issues. You may need to register orders abroad or contact exchanges in other jurisdictions if the money is transferred overseas, which increase the time and complexity. You may click the comment section down below to obtain the checklist that may offer you an insight as to what are the documents to be prepared for such kind of action. So in summary, if Bitcoin is on exchange platform, you can freeze and seize it like a bank account. If you win the case, you may recover their values. If Bitcoin is in a private wallet, you may put some court pressure such as an examination order and contempt to court. If the defendant hides it well, you may only get the monetary judgment and pursue the equivalent cash value from their other assets, which is very difficult if not impossible. Now let's conclude the video. Despite that the court has recognized that crypto is legally protected properties, the damages are likely to be calculated at the value back when it was misappropriated, not today's price. However, the cost of action may have a large impact on the damages to be assessed. Another issue is that the court may grant injunction against the crypto assets, but in the final trial, the court will almost always award monetary compensation in dollar amount as opposed to in the form of crypto. Enforcing cryptocurrency judgments could be a complicated legal procedure involving forensic blockchain tracing and sometimes criminal or cross-border enforcement work. The specific tactics and chances of success depend heavily on where the crypto currently sits, the speed of your responses, and available evidence tying wallets to real persons or accounts. At the end of the day, recognition is one thing and recovery is another. Would these legal risks make you more cautious about investing in crypto, or do you think this is a sign of growing security for digital assets? Let me know your thoughts.